Do you think it's a good time to start?
Yeah, we can probably get started now.
Okay, great. Thanks. Okay, so a warm welcome to everyone from Inclusive Education Canada. We'd like to thank you for joining us tonight. I'm Andrea Cameron, and we're here for our part two webinar, What to Do When Your Child is Excluded from School, with Lila Refaie from Arch Disability Law Center. So thank you for joining us tonight, Lila. As we gather virtually from across the country, I would like to acknowledge the many Indigenous lands we are joining from today. From coast to coast to coast, we recognize the territory of all the Inuit, Métis, and First Nations people that call these lands home. In our work for inclusive education, we recognize the historical and ongoing impacts of colonization. We are grateful for the opportunity to learn and work together in a spirit of reconciliation.
So today we are going to work through the questions that were submitted from our last webinar, and also through our online survey that we had put out. So we're going to do those first, and then we will move to questions that are from the Q&A. So to submit a question, if something comes up during the webinar that you're wondering about, there should be a button at the bottom of your screen to click on Q&A, and you can put your question in there. So if we have time for those, we will do that. When you submit a question, please do not include any identifying information, if possible. That would be great.
Thanks, Charlotte. So we had the pleasure of hosting a webinar with Lila back in January as the launch to National Inclusive Education Month. Lila was able to provide families with first steps, or in many cases, the next steps on their journey to getting their child back into school after a partial day schedule or full exclusion. This issue, we know, impacts thousands of families and students across Canada. So for Inclusive Education Canada, this is alarming at how many people this is impacting. We don't accept the widespread denial of students' rights to an education. By excluding students with disabilities from our neighborhood schools, we all lose, whether it's through partial day schedules or full exclusion. We know that students with disabilities then miss the experience of learning alongside their friends in our public schools. They're often missing their education entirely. We know that teachers are missing the opportunity to know this great group of students. We know that exclusion from school creates lasting academic and social harm. Effective school inclusion strengthens schools. It empowers teachers and creates a foundation for healthy communities. We also know the extra demands, the advocacy demands that school exclusions place on families can cause things like employment disruption, demands, stressful demands placed on the family, and financial consequences of school exclusion can be devastating. Schools need to be strengthened, families need help, and students need their education. So let's hope this webinar contributes to that overall effort. So I'm going to take a second to introduce Lila. So those who were at the first webinar would have met her then, but to give a little bit of information for those who weren't. So Lila was called to the bar in 2012 and joined Arch Disability Law Center in July 2017 as a staff lawyer, offering legal services related to disability rights and persons with disabilities in Ontario. Since 2019, she's the bilingual staff lawyer and student program lead at Arch, providing legal services in both French and English. In addition to providing direct legal services to persons with disabilities, she also delivers public legal education and presentations to members of the legal profession and Arch's communities on a variety of topics. Throughout her legal career, Lila has appeared before several administrative tribunals, the Superior Court of Justice, and the Divisional Court. Thank you for joining us to help families navigate this difficult situation.
Thank you so much for inviting me to come back.
So we'll start with the first question we have. So it's got a little bit of a background there. Children in care are in survival, fight or flight, and often they're having a lot of difficulty regulating calm. And they are often excluded for long periods of time with no real plan for extending. What steps could be taken in this situation to increase student time at school? And so I assume when the person who asked the question says care, they're meaning foster care, I'm assuming, when children are in
Mm,
care.
Okay. Yeah, and gonna assume that they mean that they're when they're excluded often, that potentially, we're talking about shortened days as well,
Mhm.
in that sense, from where the question is, how the question is framed. Um, so, for students with disabilities, it happens quite often that the schools kind of just decide to either shorten the days of a school day for a student, or just flat out, tell the parents that maybe, today the student should not come in school if they're not regulated, or if they're not calm, or if they're not under such and such condition. And most of the time this happen in very informal ways. So the steps that a parent should take or could take to increase a student's time at school in these kind of situations, it really, I guess, starts with, or at least my suggestion would be to start with getting or organizing a meeting with the principal, potentially, the superintendent, or any other relevant staff at the school board, from the school board, to have that first meeting if it hasn't already been done, and figure out, like, what is the holdup? What is it that, this student may need at school in order to not be dysregulated, if that's in fact the case. And figure out, like, maybe there's more supports that are needed at school, right? In order to increase their time at school so that they can attend full time. And that's a discussion that the school should be having, and that's a discussion that they should be having with you as the parent. So I think that would be the very first step to take, is to really figure out, okay, well, is there supports that are missing here, for that student, right? That makes it, that just gets them to be excluded, or to have their days cut short all the time for whatever reasons that is maybe due to their disability. I hope that answers that question.
Yeah, and I
Yeah.
myself had an extra question kind of attached to that. It says, for long, they're excluded, where was it? For long periods of time, like sort of with no end in sight. Like, is it helpful to
Mm.
get a date at which like something is done? Is it helpful to get a date in writing, or is that possible?
Absolutely. I mean, if we're talking about like a long-term exclusion, which, to be completely honest and direct, that's usually what exclusions are. That's like a time that there's no end in sight, right? That's usually that they put in the schools will put in like these ridiculous conditions. Like, the student can only come back to school if XYZ happens. And that could result in months and months of being not in school. Um, so of course, if that's what a parent is facing, where the school is just saying, no, you can't come back to school for don't know when. We're just gonna have to wait and see. Definitely push for a return date. Definitely push for to know why. And I think that's really the key, is like, why can't they come into school before whatever date, if they give you a date? Why is it taking so long? Right? What is the holdup? And and it's not to justify it, but it's just for you to get more information at the very least, because from that information, you could really figure out, okay, what's the next step after that? Because if they're telling you, well, we don't have enough staff, or we're not sure what to do, and they're just dragging their feet, then at that point, you have something to go to use, right? To either push them for more meetings, push them to move a little faster, or maybe talk to the trustee at your school board to say, listen, this is not, the school is not doing anything right now, and I don't understand why it's going to take 6 months before my child can go back to school, right? The reason they're giving me should not take 6 months, or they're not giving me a date. So it's really like, the first thing is really the first step in all of this is always to get more information. Because
Hmm.
from our experience, schools can be very cryptic. They can be just very, very general, very, not really wanting to give any information to parents and just saying whatever, hoping that the parents will just accept it and not do anything, and then that gives them an out, really, to not press on or not, move fast enough. But it's when, you're asking for that information and you hold it up against them, right? The other thing I will also say, because there is a situation where, the school's not making it an official, right? They're not giving you a letter of exclusion.
Hmm.
They're just telling you for months on end or weeks on end, the student can't come in yet, can't come in yet. If there is nothing in writing, if there's no official decision, then I would say to push for a decision. Saying, okay, if you are excluding my child, give me a decision in writing. And the reason I'm saying that is because then that engages the appeal process for an exclusion decision. And that gives certain rights, to appeal the decision and really to try to reverse that decision a lot more quickly, or at the very least, it may trigger, a whole process that the school has to engage in to ensure that an exclusion doesn't last too long.
So, as scary as receiving a letter of exclusion would be, it's actually more helpful in getting your child back into school faster because you can then appeal it rather than an
Yeah.
endless kind of vague. Okay.
Yeah, yeah.
Yeah.
That's what I would argue for sure.
Okay, next question. So this is about a student who has nursing and EA support. So the student is full-time has a full-time nurse for health reasons, oxygen and a feeding tube. If the nurse is not available or the EA at school, the student is not allowed to attend or not able to attend school. What steps can be made to rectify this?
Yeah, that's a very good question. And especially with the EA not attending is something we do see very, very often in schools where, there's maybe just one or two EAs in the whole school. And if they're away, then, the student can't come in. That's really what the schools keep telling parents. Um, but the reality of things is that the school has still a responsibility to ensure that there is the appropriate supports and accommodations in place for that student in order to for that student to attend every day, to get their education. It's not, it's not dependent on a particular, usually it's not dependent on a particular EA or nurse necessarily. So like if someone is away, then they should be ready to provide a replacement for that time. The same thing could be argued if your teacher is away, right, for a period or for a day or two, that you don't tell all the students to stay home. You have a replacement teacher, right, for that day. Of course, there's a bit more complexity, right, in terms of the type of supports, right, that the EA may be providing or the nurse. But if as long as the IEP allows for it, if there's um, an EA support that's there, it's not generally, and schools would most likely, or 99% of them would never do like just attach one person, a specific person to a student. They would just be more general. Then why can't they provide a replacement EA for that day, right? So it really comes down to the school and their duty to continue to accommodate, to continue to provide the supports. And so, um, yeah, so that's their responsibility. What steps that someone could take really to rectify it, that the situation? I mean, if the school is refusing, and this is happening more and more often, they're refusing to allow the student to attend because the EA or the nurse is not there, or that specific EA and a specific nurse is not there, I think a complaint to the school board will probably be the first step to go. Um, Potentially, I mean, I would generally suggest, first contact your superintendent. Um, but just to be completely frank, most likely that they'll just take the school side. But that's when, if your school board still has trustees, then it would be good to engage with your trustee as well, and let them know because they're there to help parents, or they're supposed to be there to help parents, right? To navigate these issues with the school as well. Um, but yeah, bring it to the school board saying, listen, this is ridiculous. Uh, there is, there is these supports in place, and a child's education is not dependent on whether or not that support or that person takes a sick day. There should be a replacement or some kind of plan, right, in place to ensure continuity of education.
Thanks, Lila. Okay, the next question is, this is an interesting one. Are suspensions of students with disabilities considered to be exclusion?
So legally, no. There are two very different things. So a suspension, at least in Ontario, and I'm gonna assume most likely the rest of Canada as well. But suspensions is really about discipline, right? There's an action, an act that happened, or an incident, or I should say actually an alleged incident that happened, and that falls within one of the various categories in the Education Act itself that would be considered grounds for a suspension. And the decision from the school is to suspend the student. Whether, with disability or without disability, it's not relevant necessarily, but it's really about the incident itself. And it's disciplinary, it's a disciplinary measure against a student. And it could be, it's very it's very short. It's, between 1 and 20 days, at least in Ontario. And there is a very, very distinct appeal process in place for suspensions that is actually stated out in the Education Act. Whereas exclusions is solely for safety concerns. Um, and that's how it's stated in the Education Act in Ontario. And there is a right to appeal, but the process itself is kind of dependent from school board to school board. And there is no specific timeline as to how long an exclusion can last, right? So it's very, very different. And it's an exclusion is supposed to not be disciplinary. So it's not supposed to be about discipline. It's not about, a matter, a way to discipline a student. It's really, really about that there's some safety concerns with regards to that student against themselves or against their fellow students in the school. A very important distinction for sure to
Mhm.
make between the two.
Yes. Good thing that question
Mhm.
was asked.
Mhm.
Okay, so how long can a school district suspend a student for? Are there any limits, and at what point does it become discrimination when it is a student with multiple diagnoses and they have been suspended for over 6 weeks by a public school district?
Okay. So from the wording of that question, I'm not sure if it's an Ontario district that they're referring to, but I can only speak about, how the rules are in Ontario. Um, One, suspension is actually it's not from a school board or district, it's really from a specific school. And in Ontario specifically, suspension cannot be longer than 20 days. And that's really stated in the Education Act itself. So it's legislated. No school board or school can change that. It could be less than 20 days, but it cannot be more than 20 days. at least per suspension. And I say that because there are situations where a student is suspended once, they come back, a couple of days later, they get suspended again. And that's when, it becomes a bit problematic. But yeah, so there is a limit uh, of how long a suspension can last. And I should mention it's 20 school days that the law actually says. So not just calendar days, it's 20 school days. And for the second part of the question, which was about any limits or whether it becomes discrimination, right?
Yeah, if the person has like disabilities
Mhm.
or diagnoses, yeah.
Yeah. So in Ontario, the Education Act does set out some important factors that a principal has to consider before suspending a student. And one of those factors includes, that if the student is a student with disability, is there were the alleged incidents, caused or as a result of, their disability, right? And that would mean that they may not be able to suspend for that reason, and they have to look at other options. So it's not the fact of, students with disabilities can never be suspended, but if the behavior itself that led to the alleged incident is disability related, then that, could mean that the principal should not suspend the student. It should not be disciplining the student for disability related behavior, but rather be looking at whether there's supports that needs to be either changed or more supports added or something like that. All right, taking it really from a different perspective. Because we have to remember a suspension is really meant to be disciplinary. Um, and um, and it's because a student, in the eyes of the principal, did something wrong, right? Whichever, whether it's, for example, like they brought a weapon to school or they got into a fight with another student, etc., right? These kind of, there's a long list in the Education Act, but it's really meant to be, much more of a straight out disciplinary measure. I cannot say whether, uh, if mainly because I don't even know where this question is from, like in terms of which province, but I don't know if over 6 weeks would be considered okay or not in another province, just because I don't know the laws. So for that person, like if this is based on, their situation, I would also recommend maybe you speak to a lawyer who practices in education law just to see if there's anything else particular in in their situation. But I could say in Ontario, 6 weeks is would probably go over the 20 school days. So I would also suggest, if they are in Ontario, to contact you could contact Arch, to get some more specific advice really about the length of time of a suspension.
Okay. Are there any legal repercussions that are immediate and can help to get a student back to school on a regular full day schedule?
Uh, Fortunately, there isn't. There isn't anything that would force it. Um, if the school is willing to work with you and willing to get that to get the student back in school as quick as possible, and they're open and they're have good conversations with them, then I would say that is the best way to do it. That is the ultimate best way. That's the quickest way, and that is the way that's going to bring you the quickest and most satisfactory result. Um, Legally speaking, beyond that, there are different ways to legally force a school to get the student back to school in a regular full day. But, we're talking about like litigation here, and that takes time. And a lot of times, we're talking about at least a couple years. Now, If the question is referring to, that a student got excluded and that there is a an official decision made on that exclusion, then there's also, of course, the appeal process, which is an appeal that's done with the school board. That generally could take just a couple of weeks, but if the student is not on the full day schedule though, and they're on shortened days instead, then the school board, the appeal process will not help with that. It will just help with the exclusion itself,
Mm.
but not necessarily bring the student back to a full day schedule necessarily. They'll just decide, no, he should not be excluded and he needs to be back in school. Um, what that back in school would look like, that remains on the school to determine that, right, from that appeal. Um, the other way to maybe get more quick results or immediate results is if your school board has trustees, then to get your trustee to get involved, they can be sometimes very helpful, um, in terms of ensuring that the student is back in school or, in their school board, that they're attending school for sure. But yeah, that's would be my suggestions really for the more quicker ways to get students back to school on a full day schedule.
Thanks.
Okay. What can you say when the school tells you that the student's behavior is communicating that they cannot handle a full day of school, but as the parent, that insisting on a full day of school is actually not meeting the needs of the child with disabilities?
Hmm. It's a very interesting question, actually. So to me, I hear this question, I'm like, there's so many questions, follow-up questions that come to mind. What does that mean? Right? What part of their behavior is saying that to a school staff, and what kind of evidence do you have? Was there any assessments done? Was there some recommendations by an expert that the parent may not be aware of that is informing the school? So I think the very first thing to do is to get information, right? First and foremost. Because school, and I do believe, schools would talk about these kind of, will state these kind of very vague and general statements to parents to kind of, justify what they're doing. But they don't always have something to back it up. And and I think parents need to kind of push back on that, on those kind of statements. So, I think one or the very first thing to say is like just ask them like, okay, well, you know, have you been documenting this behavior that's communicating, whether or not the student is ready? And if so, like what, show it to me, right? Tell me what it is that of what kind of behavior is happening in school, because clearly there is a miscommunication, there's a disconnect because the parent is not on the same page as the school. Um, and um, you know, ask them just point blank, ask them, where is this recommendation coming from? Under what circumstances are they stating this? Because I'm assuming most of the time, like there's already been an assessment done, right? There's already been recommendations. There's probably already an IEP in place. So the parent would have seen all those. So if there is something new, that is now all of a sudden saying that, well, they need to have a modified day or something like that because of disability, because of their behavior, then that must be coming from somewhere. And I could probably take a very good guess to say that most likely this kind of situation is probably that, the teacher doesn't want to deal with that student for a full day. They're saying they're blaming the student for it. Because we have seen that happen a lot, right? And that is not that is not appropriate to then use that by the school to say, well, actually, their behavior means that they can't be there full day. Well, no, it's your lack of supports that means that they cannot be there full day, right? It's really about that, not about the behavior of the students. So really, try to get more information about where are they coming from with this? How did they make this conclusion? Turn it back on them, really.
Oh, all right. Um, so the next one is we've kind of talked about this already. How do I appeal the decision to exclude my son from school? We kind of talked about appeals already, but maybe like what will be the first step to
Yeah, for
start an appeal?
yeah, sure. The first step and is depends on the school board. Each school board has very different a very different process to actually appeal. But generally, it starts with some form of the parents sending a letter to the school within a certain amount of time. And there are deadlines that are for appealing these decisions, and they vary from school to school, or from school board to school board. So before even appealing the decision, ask for the policy on appealing exclusions. And then you'll have the information and you just follow the step by step that should be outlined in the policy.
Oh, you're muted, Andrea.
Right. No, I think you're next, right?
Yeah.
Yeah.
Can you explain the duty to accommodate?
Yeah, that's that could be a whole presentation by itself. But and I just conscious of the time. I can't go into too much detail, but what I can say maybe very quickly about what the duty to accommodate is, it's essentially a legal obligation, in this case, in this context, by the school board and the school. To provide appropriate disability-related accommodations to students with disabilities so that they can attend and access education. Um, Now, the duty to accommodate itself, it's like I said, it's a legal obligation. It involves a very distinct process that the school boards and the school needs to engage with the parents of the student with disability in this situation, since the student would be a minor, where first off they have to work together to figure out what the um, disability related needs are at school for that student, like what are their needs and what kind of supports or accommodations should be put in place for that student to be able to access their education. So that process includes a lot of, discussions and meetings between the school and school board and the parent. Could involve as well some disclosure or exchange of information about the student, about their disability needs, and maybe potentially as well some assessments that could be done to identify what supports are needed for that student in school. But it's also important to remember that the duty to accommodate is only up to the point of undue hardship. So undue hardship is kind of like a legal limit to accommodations, which means that the school boards have to accommodate unless the accommodation causes undue hardship. And that undue hardship would mean like if it's excessively costly. Not just that it costs money, that's okay. If it costs money, that's okay. They have to pay for it. But excessively costly, I'm talking about, goes beyond their budget, basically. Or if there's health and safety concerns with accommodations. Now, even if there is an accommodation that reaches the point of undue hardship, that doesn't mean the school board can just wash their hands and just move on. They still have an obligation to continue in the process to try to identify if there's another accommodation or support that is not undue hardship, but could also meet the needs of the student. So like an alternative accommodation, right? So, I could try to think of an example here. Um, if the student, let's say, needs a completely, let's say, just for argument's sake, a completely silent room, for example, to do the an exam, let's say. Um, Now, maybe in that particular school, it would not be possible um, to create or build a complete soundproof room aside because of cost. It would be excessively costly. They don't have the budget for it, and literally they don't have the budget for it. Now, alternatively, they could say, well, we can't do the room. But what we can do to accommodate is provide, the student with a quiet space and with headphones, noise cancellation headphones, and, would still create that quiet space for the students. So that would be an example that I could just think of right now of, an alternative situation that is not undue hardship, but still meets the needs of the student to have a quiet space to do their exam. So for in during the due to accommodate process, it can take a bit of time. It's not depending on, how if there's any assessments or needs that needs to be done with the student, but it shouldn't necessarily take too long, right? The schools have an obligation to provide the accommodations needed within a reasonable amount of time. What that reasonable amount of time means is up for debate. But that's when, generally we're not talking about months and months necessarily, but it could be more than a day sometimes. Um, yeah, I mean, I'm happy to, I know there is a lot to say about the duty to accommodate of a school. Definitely, and we're happy to also, if that's something of interest, to provide like a whole other webinar on the 101 of the duty to accommodate, because there is a lot that we could cover under that. But that's basically, the essential, you know, 5 minutes rant on duty to accommodate.
Well, it's just important too for people to understand that
Yeah.
responsibility and have that language. Um,
Mhm.
yeah.
Yeah,
Okay,
absolutely.
I'm next, right, Charlotte, for the questions? Yeah. Okay. Uh, my child is on a partial day schedule, and when he's at school, is learning in a room outside the classroom. He doesn't actually seem to be learning anything. There's no evidence of planning for him, nor is there any effort to share what his class is doing. What should I do? So it sounds like an exclusion within the school, plus a partial.
Yeah.
Yeah.
Yeah. I mean, a lot of things could be at play here. Whether that's, I don't know if that's part of the IEP necessarily either. Or is it that the student is just placed in another room just because, Um, I think regardless whether, one way or the other, I think it is important that in these kind of situations that you meet with the principal and potentially the superintendent if needed to really get a sense of, first off, show me what's going on in that partial day during in that separate room. What is the teaching? What's the teachings? Right? What is the student doing? What is my child doing? Um, they should be able to at least show you that, right? There should be some kind of schedule, some work or something, right? To show. Um, and so that's one thing, and you could get some more information about that to really kind of be on top of it, be on top of the school and telling you like what is the learning plan? Why is there nothing, in writing, and why is this not um, progressing to anything? Now, as for the partial day schedule, that's, another separate issue, to determine, if it is something that, the student needs to be, um, on the full day schedule at this point, or whether that's an accommodation to be partial day. I'm not entirely sure. But if it is an issue, that does need to be discussed as to what's the plan. Is there a progressive plan to get the child to be at a full day schedule? And how do we get there, right? Sometimes there's milestones that are in place. Sometimes, or it's what we were talking about earlier in an earlier question, maybe just the school is claiming that there's a behavior issue. But then you could get a bit more information about that as well.
Alrighty, what is a proactive response that a parent can use or say when a school calls them to send their child home?
So, I mean, I think a lot of it does depend on what the reason is, but and this is a very tough question to answer, to be honest, because there's of course, they have the obligation to keep providing the education, right, to the student. Most likely, if this is something that's happening often, there is supposed to be some kind of plan in place. If a student is triggered that, to the point where they need to, um, that the school feels that they should be going home. Um, you know, it is to question, okay, well, did you go through the plan? Did you go through the step by step, right? Why do I need to pick them up right now? And there's no necessarily like an obligation, right? If they're not excluded, if they're not suspended even, um, then there's no reason for them to go home, to be sent home, right? There is supposed to be, the supports are there in order to deal with anything that happens at school. But schools tend to be very quick to call the parents, right? And then if the parent says yes, I'll go pick them up, then how that actually is translated in the record is that's a parent approved absence, as
Mhm.
opposed to an exclusion, or as opposed to that there was a lack of supports, or that there was, maybe no EA that day, so they couldn't keep him, right? Instead of putting the fault on the school, they make it as it's the parent that does it, that's approving this. Um, and that makes a difference in the sense of identifying how often kids with disabilities are being excluded, because it's very hard to distinguish, whether a school is sending a student with disabilities home all the time, and well, the parent is just coming to take their kid out of school for the day, right? And it's approved, and so there's no problem. So a proactive response, I mean, it's always tough for me to answer these kind of questions, because we do get a lot of calls like this, but I think that the parents have a choice. They don't necessarily have to say yes to it. Of course, you run the risk that the school will just say, okay, well, then we're going to exclude them. All right, we're going to do an exclusion decision, which, is one of the options that could happen. But on the flip side, they could just get used to it and not be following the plan at all. Um, and every time something happens, a minor little thing happens, they're just going to keep calling the parents all the time, and that is not okay to allow them to keep doing that either. Yeah. So I hope that answers a bit
Okay,
that
yeah.
question.
Yeah. Yeah, there's lots of reasons why without knowing the reason. Yeah, it's a little tricky.
Yeah, it is.
So this next one is about pre-primary programs. So
Mm.
the question is, it's an interesting one. Why are there pre-primary programs in schools if the students there have no access to the school support, like EAs? They said TA, so I'm assuming it's outside of Ontario. Yeah. So I don't know if
Um,
that's something you've encountered.
Yeah.
Mm.
I mean, it's just, I'm not entirely sure how to answer this question, to be honest. Because it seems like, like a decision made potentially by government or school boards themselves as to, that split.
Mhm.
But it's definitely, I do understand, the lack of logic in it. I don't know if it's a funding issue. It could potentially be a funding issue, that they would only fund those kind of supports in pre-primary, but they wouldn't do it once the child is in first grade. Um, and I think that may be more of an issue to do, like that could be resolved through lobbying with the government, right, about making those changes.
Yeah, my
If
experience
that's
as a
what it is.
parent, oh, sorry, I
Yeah, no, go ahead, go
interrupted you.
ahead.
My experience as a parent was that we went through, it was called inclusive childcare. So it was separate from the school. And so
Oh,
they
okay.
provided the extra support in the daycare, um, which was in the school building, right? So
Yeah.
I think that's where, yeah, that's a tough one.
Yeah, like in that kind
It
of situation,
wasn't the
it's
school that provided it.
okay, yeah. So then
Yeah.
then in that case it's not it's not the school's responsibility to provide, like, to have that necessarily. It seems that it's maybe more of a contract that they have, that
Mhm.
those programs may have, or some kind of, like, I would probably think that there's like a funding component to that, that they're only gonna limit their services to a certain age group in daycare and not provide it at the school. Which brings me back to, I think that the best way to resolve these kind of things is really to go, to deal with through legislation changes or government changes on whoever made those decisions or is making that distinction for that program. Because I'm assuming these are probably government funded programs,
Mhm. I
for the most
assume, yeah,
part.
if they're in the school, I think. I'm not sure. Yeah, this is a good
Yeah.
question. Let's
Well,
say
yeah.
to whoever asked that question, we'll try to find out and let you
Yeah,
know.
but it's a very, very interesting question for
It
sure.
is. Yeah.
Absolutely.
Yeah.
Absolutely.
Okay. So this person would love more dialogue around safety plans. Who are they by and how are they written? Are they legalish documents? I'm wondering because all of my child's exclusions have cited safety as the reason he is being sent home.
Okay, well, essentially, I mean, I'm not surprised about the exclusions citing safety, just because that is the only reason a student can be excluded. At least in Ontario. It really has to have a safety component to it. Whether or not it's true, it's a different, conversation. Whether or not, what the school is alleging is actually safety concerns or not. But a decision to exclude has to, at least in Ontario, has to be related to safety concerns. And that's regardless whether there's a safety plan in place or not. For the most part, what we see more often is that in these situations, there is usually a safety plan in place already. And those safety plans are generally written by the school, right, by the principal, in the same way that the IEP is. And they're determined by assessments or recommendations from experts, um, through, looking at what the students' disability related needs are, what their triggers are, what is a safety concern, and what are the strategies that would work for that student, right? A lot of times, we have there's safety plans for students who elope from school, right? What is the step by step that staff needs to do if there's a concern that they're going to elope that day? And that's just one example of many other different things that could be included in a safety plan. Um, so it's really the same thing as like an IEP, right? It's drafted by the school. It's hopefully consulted with through consultations with the parents as well before it's finalized, and that there is some, assessments uh, or or experts that come in play to really determine what should be in a safety plan. But a safety plan is really about like determining the proper strategies to ensure that, the student remains safe while in school. But definitely, a lot of times that, or at least that we've seen decisions that led to an exclusion because they are related to safety. The first thing we ask is, okay, well, is there a safety plan? What was in it? And more importantly, did the staff follow it? Right? And that's a lot of times is where we get a little bit of a hiccup there. That maybe there was something that was not followed through. If again, assuming if the allegations in the exclusion decision are true, right? If the incident actually did happen, um, then, a lot of times, there was something in the safety plan that wasn't followed and that led to the incident, right? And we could sometimes pinpoint that to that.
Okay, so we have a question from the Q&A. So this is interesting. It's sort of a reverse situation. So what if the parents are refusing to send their child due to disability and being in medical mode? I'm assuming like the parents are thinking very medically. And again, as a parent of someone who's medically complex, I've been there. How can you help them change the way they feel to allow their child to attend?
So the parent is keeping their child at home?
Yeah. And so I'm assuming this is someone who works in some sort of support or advocacy.
Okay. Yeah, yeah. Um, yeah, I mean, I think one of the things maybe is to figure out the reason why they don't want to send their child at school. Because I have encountered some situations like that where clients would tell us, well, no, I don't want to send my child to school, knowing, what the potential repercussions of that could be. But when you do a little bit of digging, it comes down to a lot of times that, oh, well, my child's not safe at school because the school is refusing to accommodate, refusing to provide support. So they're not safe there. And it's really more of a, like protecting the student, their child, right? And then that if once you kind of hone down that part or that reason, if that's the reason, which it may very well be, or some variation of that, then at that point, we could, you know, help or you could help the parents to engage with the school, in terms of, okay, there's an issue with the supports, right? If there's supports that are being provided, they're not adequate enough. And we need to have a meeting to be able to provide the right supports for the student because they cannot be in school without those supports. And to really get that meeting going, get that conversation started. Because the whole process and back to the earlier question about duty to accommodate, but the duty to accommodate, it's a process, right? The accommodation process, it is ongoing, right? There are situations where maybe the accommodations that were identified at one point are no longer working, or they're not being implemented the way they should by the staff, and that's creating problems, which results in, the parents feeling like they can't send their child at school. So I think that could maybe be a way to try to resolve that kind of situation. And
Yeah,
this is, I'm
and I
assuming, no, sorry.
no, go ahead.
Oh, I was just gonna say this is all assuming that, deep down they want to send this child to school, right? I'm
Mhm,
not
yeah.
talking about situations where they want to homeschool their child, which is completely fine too, or they want to send them to a different program, completely fine as well. But just if it is that they want to send them, but they can't.
For our family, because I relate to this question. I was very nervous to send my son, and I didn't feel like I, even though I trusted the school was going to do their best, I didn't feel that he would be safe. So then we had to break it down and say, what would make us feel safe? Like what would be our ideal? And then it was interesting, like, then you sort of, we had way more support than he probably needed at the beginning. And then over time learned what he actually needed. And he had a more, like, I think this person's talking about that medical model. We moved more towards a social model over time.
Mm,
And maybe we obviously would prefer for families to go straight to the social model of inclusion.
sure.
But I think that when you're dealing with complex medical situations, the families and the student also have to feel safe too, right?
Yeah,
So yeah, it's
absolutely.
definitely a nuanced thing. So we have
Absolutely.
more chat Q&A questions. I think, yeah. So three questions total. Maybe we can get to them. I don't know.
Oh, I'll
Charlotte?
try.
Yeah.
Yeah, we'll try. Mhm.
So, how do you recommend parents advocate when a neurodivergent child is suspended, but the disciplinary approach feels punitive rather than supportive of their needs? In our case, we've raised concerns both with the school and the board, but they continue to apply a standard code of conduct designed for neurotypical students without considering alternative, more learning focused approaches. What strategies or escalation paths would you suggest?
That's a good question. Um, I mean, in any like if there's a suspension, they are meant to be disciplinary, right? But through any decision to suspend a student, if the student has disability and there is disability related needs or disability related behavior that come into play, that's a school's obligation to consider that. And not only to consider it, but really to really think through about, well, what are the supports that should be in place, or if there's anything else that they should be doing from a human rights perspective, from an inclusive education perspective. So, from my understanding of this person's situation, if they have already discussed all that with the school and the school board, they're not budging at all. I don't know why, they're not budging. There could be a whole bunch of reasons, and of course, I would always suggest that, for a specific situation to get legal advice. They could get into a bit more of the details as to what's going on. Because it could be that they don't agree with the parent's assessment. Then why don't they agree with it? Is it the lack of information that they're having? Is it that they don't think it's true, right? They don't believe it, or anything like that. But putting all that aside, if the school and school board are still refusing to even consider, and all they're doing is suspending over and over again, it may be time to think about, filing, potentially filing a human rights complaint for discrimination, against the school board itself. Now, I'm saying this without knowing all the facts, of course, and I do really urge that person to get some legal advice. But the reason I'm saying, maybe at this point, if there is nothing else that's going to convince or change their mind, at the school board about continuously suspending them, then maybe it's a bigger issue than just a suspension, and it's really about discrimination against the particular students themselves.